Welcome to part 5 of this video series. My name is Markus Wesaw and I will be your facilitator for this presentation entitled What is OSHA? An Introduction to Health and Safety. If you have any questions regarding this material, feel at liberty to contact me using the information provided on the screen. Probably one of the more controversial topics that I teach about involves the employee right to complain or request corrections regarding unsafe working conditions. Employers, especially those in management, have a tendency to strongly dislike this particular topic. However, we are at a point in America where unsafe working conditions should be an issue of the past, although nothing could be farther from the truth. This is a two-sided coin type of an issue. Firstly, employers have to deal with a great amount of employee-related issues, and adding more complaints in addition to all the rest can be quite daunting. Secondly, if you have done as many safety audits and site inspection visits as me, you would find out quickly that numerous employers fail to adequately address quite obvious safety and health hazards within the workplace. Without being too officious on this particular matter, I'm going to attempt a neutral position and present the information as fairly as possible. If an employee notices a safety and health hazard within the workplace, that employee should first attempt to eliminate or abate the hazard. Where the employee is unable to do so, the safety or health hazard should be reported to management in order that the employer can work on eliminating or abating the hazard found. This would be an optimal scenario. Again, this is a two-sided issue. Employees are remiss when they do not report an obvious safety or health hazard within the workplace, or when they fail to correct the hazard if it is within their power to do so. Employers are remiss when employees report unsafe working conditions or hazards to management only to have the complaint dismissed with no further action taken. Management should welcome safety and health complaints for a variety of reasons. Furthermore, employers can face significant and negative consequences under the current OSHA regulations for unnecessary reprisal against an employee who requests corrections or complains about a safety and health hazard. Moreover, employees should make a concerted effort to eliminate or abate recognized safety hazards within the workplace whenever possible to ameliorate the hazard from the workplace. Conversely, employees' complaints that are beyond the scope of health and safety regulations should be avoided. The key on this important issue is to strike a perfect balance whenever possible. I do want to emphasize one thing. If an employee brings up a valid safety or health hazard within the workplace as a complaint or to request a correction of the safety hazard, reprisal from the employer against that employee can lead to significant consequences, which isn't really good for either party. Employees have a right to training about the safety-related issues within their particular work environment. As a college instructor and professional trainer, I find that employee training is a monumental, gargantuan deficiency with most employers. The real issue comes down to a lack of training. Employers, in general, want a workplace free from known and recognized hazards, but many organizations do not make a connection between hazard recognition and employee safety training. The primary problem regarding safety training within most workplaces is the cost of the training, loss of productivity, and the cost of having employees paid to attend a training. Without seeming too cynical on the issue, OSHA has been an enforcement agency since 1971, and I'm not quite sure at what point safety training became optional, if ever. Employee safety training is a definitive right to an employee, and employers should honor this right. Employers should find a way to make safety training cost-effective and efficient. There are numerous resources available at little or no cost. For example, there are many Susan Hardwood grants issued each year by the U.S. Department of Labor, and the training materials from each awarded grant becomes public domain. One can get numerous training resources and materials from the OSHA website at www.osha.gov. Additionally, OSHA has a consultation program available where an OSHA consultant can actually go to the workplace and provide training for an employer so long as the agency has the time and resources to do so. It is a ridiculous notion to require a job candidate to have safety training from a previous job prior to hiring that person. Safety training is likely to benefit the employer most when the training is site-specific. Of course, having a background in occupational safety and health from a previous employer is certainly useful. This does not entirely remove the need for additional safety training in a new work environment, new job position, etc. Listed on your screen in the second bullet point, you will see a list of very common safety training topics such as noise exposure and hearing conservation, confined space safety, personal protective equipment, etc. This is just a basic idea or a starting point to increase your awareness as an employee or management team member. Again, the idea is to make safety training both cost-effective and efficient in order to enhance the likelihood of injury prevention within the work environment. In numerous work environments, employees are exposed to high levels of noise and other types of toxic substances. Sometimes employers refer to these specific types of work-related hazards as industrial hygiene concerns. The most common examples of toxic substances and harmful physical agents are metals and dusts such as lead, cadmium, and silica, biological agents such as bacteria, viruses, and fungi, physical stressors such as noise, heat, cold, vibration, repetitive motions, and ionizing or non-ionizing radiation. Employees who encounter these types of physical stressors, biological agents, and toxic materials or dust will likely be required to undergo some type of occupational health testing from a licensed healthcare provider. The employer is required to provide an effective industrial hygiene program when exposure to these types of hazards are present within the workplace. Employees have the right to examine and access any medical records for their own review stemming from any type of industrial hygiene program. For example, if an employee is enrolled in a hearing conservation program, the employee may be required to attend an annual hearing exam from an audiologist. The audiology records would be accessible for review by the employee upon request. Handout 12A, 12B, and 12C provide an outline on how to file a complaint with OSHA. Employees are encouraged to file a formal complaint with OSHA if they believe a violation of safety or health has occurred in the workplace, or if an imminent danger situation exists in the workplace. Many employees have asked in the past about confidentiality and whether or not they can remain anonymous when submitting an OSHA complaint for fear of reprisal or just a general desire for privacy. The answer to that general concern is yes. Employees may request that their name may not be revealed to the employer when a complaint is filed. Usually upon completion of an actionable complaint, OSHA will inform the complainant of the actions taken against the employer if there were any. It is recommended, however, that employees make every attempt to report unsafe working conditions to management for correction prior to filing a formal OSHA complaint. Many times, employees and management can work together to resolve safety and health hazards within the workplace. There are cases where an employer has failed to correct viable and real safety and health hazards within the workplace upon internal employee complaints. This would be a scenario where OSHA would be notified about the health and safety hazard via an employee complaint in order for the issues to be appropriately addressed. On another note, OSHA can receive complaints from third-party organizations, subcontractors, general contractors, and other concerned individuals if unsafe conditions or acts are noticed within any given workplace. Remember, OSHA has jurisdiction over the employer-employee relationship and can step in for corrective action when a concerned person or company files a complaint. You have reached the end of this video presentation. This presentation has been produced by MW Consulting, LLC. Feel at liberty to contact us directly. Thank you.